Thank you, Chairman. 21 RS 0619, concerning sales tax relating to exemptions defining as nonprofit community care organizations.
Thank you, Representative. Committee questions? Any objections? Seeing none, the request is approved. Any further requests for bill introductions? Seeing no further requests for bill introductions, we will close that portion of our business and move on to our first item for the day, a hearing on House Bill 2173. For an overview of 2173, I would look to the Revisor's office for an overview. Thank you.
Thank you, Mr. Chairman. House Bill 2173 would require the collection and remittance of sales, compensating use, and transient guest taxes and other prepaid wireless 911 fees, by a marketplace facilitator in the event that the marketplace facilitator has sales subject to tax in the state in excess of $100,000. Additionally, the bill would provide Nexus for certain retailers with sales in the state also of $100,000. Going through the bill a little more in depth, Section 1 defines marketplace facilitators as a person, including an affiliate, that contracts or agrees with a marketplace facilitator to facilitate for consideration the sale of the marketplace seller's products or rooms, lodgings, or accommodations through a physical or electronic marketplace or a platform, and also collects the payment from the purchaser to transmit to the seller. Section 2 requires that the marketplace facilitator would collect and remit the tax if the marketplace facilitator in the previous calendar year had sales exceeding $100,000 or makes or facilitates sales in an amount of $100,000. Also under Section 2, the bill would also include provision for waiver of the requirements under certain conditions when a marketplace facilitator can demonstrate to the Department of Revenue that its marketplace sellers are already collecting and remitting the taxes. And if this is the case, the taxes would be collected from the sellers. Lastly, under Section 2, any marketplace facilitator obligated to collect the taxes would also be required to collect the prepaid wireless 911 fees starting July 1 of 2022. Section 3 of the bill sets forth certain liability and audit provisions. Additionally, the department, as part of the bill, would be able to waive penalties and interest if reasonable cause exists. Section 4 would provide that marketplace facilitators would not be required to collect and remit any taxes from sales occurring to July 1 of 2021. July 1 is currently the effective date for the statute for the bill. I believe it's the statute book. That's correct. Lastly, Section 5 would amend the current Nexus statute for use tax provisions in Kansas statutes. Under these currently existing statutes, the definition of a retailer doing business in the state would be defined as any retailer who had in excess of $100,000 in cumulative gross receipts from sales by the retailer to customers in the state. Then lastly, under Section 5, what was commonly known as the click-through Nexus provisions that were instituted several years ago would be removed. And with that, I'd be happy to stand for any questions.
Any questions? Representative Highland.
Thank you, Mr. Chairman. Is that $100,000 level, is that the suggested amount that the U.S. Supreme Court made in the South Dakota versus Wayfair judgment?
It's the amount that South Dakota had in their law. I believe it's the amount they commented on. To any more extent of whether or not they agree with it or don't agree with it, I'm not. It's probably a little more of a subjective determination, but that is the amount that was in the South Dakota law.
Thank you.
Representative Mason.
Thank you, Mr. Chairman. Adam, the Department of Revenue issued a couple years ago their notice 19-04, which requires remote sellers doing business in Kansas to collect and remit applicable sales tax. They did not put a $100,000 safe harbor threshold on that notice. Does this definition in this particular bill affect that in any way, or is that separate?
No, that would affect it. That would, currently it's my understanding is the Department of Revenue is intending to collect on, any amount sold into the state that currently would not, for any business that would not have current nexus. So by making any sales into the state would create a nexus with the state requiring collection and remittance of sales tax. This bill would amend that notice to then create the $100,000 threshold. And not just for marketplace facilitators, excuse me, that would be for all retailers, not just the marketplace facilitators.
Committee, further questions? Representative Baker.
Thank you, Mr. Chairman. Adam, thank you. This bill, we had the Attorney General over last time we talked about this bill, and the $100,000, they said that was a good number, but they didn't say that was the right number. They just said it was a good number. That's what the Attorney General told us at that time. So I told him maybe $1,000 was a good number, or $10. They're all good numbers to me. 0 might even be a better number. But there was no, when he gave the opinion at that time, the 100,000 was just a number. And it certainly was high enough that it passed the threshold, but there was no way I could ever support that. Thank you.
Further questions for the reviser? Seeing none, thank you for your overview. We'll turn to Department of Revenue now for an overview of the fiscal note.
Mr. Chairman and members of the committee, this is Kathleen Smith with the Kansas Department of Revenue. House Bill 2173, we are estimating would increase state revenues by $42.4 million in fiscal year 2022. Of that total, the state general fund would be increased by $35.5 million, and the state highway fund would be increased by $6.9 million. In fiscal year 2023, it does increase to $49.8 million, and in fiscal year 2024 to $52.7 million. To formulate our estimates, we began with a study that was completed by the U.S. Government Accountability Office in 2017. We used that information that they had provided, as well as some industry data and some actual data that has been provided by other states, and we formulated our estimates for the marketplace facilitators based upon all of this information. So we also had to formulate an estimate then for the remote sellers, because this bill does provide a de minimis for the remote sellers at this point. So to do that, we went in and looked at actual use tax collections by those out-of-state retailers that have $100,000 or less of taxable sales in Kansas. What we found is that we have almost 9,000 of these out-of-state retailers that are currently registered with us that do have taxable sales below the 100,000. So we had to reduce our estimates by around 9 million or so in fiscal year 2022, 23, and 24, based upon the de minimis on the remote sellers. With that, Mr. Chairman, I would stand for questions.
Thank you, Kathleen. Representative Corbett.
The question I have for you, how many other states are doing the marketplace facilitator collecting sales tax from like this program? Are a lot of states doing it, or do you have a number?
With the marketplace facilitators, Representative, most of the states already have language in place. I believe there are only 3 states now that do not have marketplace facilitator language in place. That would be Kansas, Missouri, and Florida. And Missouri and Florida, I do believe, are working on proposals right now.
Committee, further questions for Department of Revenue on the fiscal note? Seeing none, thank you for that overview. We will now open up the proponent testimony portion for House Bill 2173. And first up, I would like to welcome to committee Eric Stafford, representing the Kansas Chamber. Welcome back to committee.
Thank you, Mr. Chairman and committee members. Good afternoon. The week is officially more than half over. Appreciate the opportunity to testify in support of House Bill 2173. Eric Stafford, Vice President of Government Affairs with the Kansas Chamber. This is a bill that we introduced this year. There's a Senate version, Senate Bill 50, companion bill. This is an issue we've been trying to get done for the last few years. Hopefully this year's the year. This bill is very similar to last year's House Bill. Oh, I'm going blank. I want to say 2553, but I think that's actually last year's decoupling bill. Anyway, we had a bill last year that we introduced on this that comes from or is based off NCSL model language. So the bipartisan legislative organization that many of you participate in, they worked with the retail and telecom industry and others to come up with model language that states can adopt, as this has been a growing trend across the country. We are one of 3 states to not pass this yet. Our neighbors to the east, Missouri and Florida, and us have yet to address this subject. So I believe it was at the very beginning, maybe 2 weeks into 3 weeks into session last year, there was discussion on whether or not to have a threshold. And the Attorney General spoke to the Tax Committee, and his comments were, as did the Secretary of Revenue. I think they did a good job, both of them, highlighting the issue and what the Supreme Court said. You know, the Supreme Court didn't say you must have a threshold. It was a pretty strong suggestion of a complete Wayfair checklist, as the Tax Foundation calls it. That's outlined in our testimony. But the quote or statement from the Attorney General that stuck with us at the time, that relatively close without using actual quotations, is basically the further the state deviates from South Dakota's language, the more inviting we are to litigation. So it is suggested to follow that as closely as possible. This bill does that, and we would ask for your support of it. This is a fairness issue. I know that some have had the conversations I've had with folks in the past. Is this a tax increase? Is this not a tax increase? Whatever format or outlet you're buying, I saw the chairman earlier fresh off of buying a new winter coat because I was getting scolded for not wearing a coat this week. And I paid sales tax with that online purchase. So whether you're buying a coat in a brick and mortar store, thank you, Representative, I appreciate your support. Wherever you're buying your product from, if it's subject to sales tax, it's a fairness issue. So that is the intent of that legislation. One piece in here that I want to highlight is the prepaid 911 fee, prepaid 911 wireless fees. That was brought to our attention last session, pre-COVID, or right around COVID shutdown time, maybe just a little bit before, and then we were getting ready to start to have hearings, and had a hearing, and then there was discrepancy between our retail members and our telecom members on the effective date and language to address the prepaid wireless 911 fees. So if I go buy a prepaid cellular phone at a retail store today, Best Buy, Walmart, Target, Walgreens, wherever, they remit that 911 fee to the state. It's included in the prepaid charge. So the question is, how do the marketplace facilitators that are selling those products address that? Who's responsible to remit that to the state, and when does that go into effect? The telecom members wanted that in effect July 1 of last year. Under this, we did a conference call, I think it was early April, and thought we were getting close to a point that we had everything worked out in terms of language, effective date, and all that kind of stuff, and then the bill never got passed. We worked with our members in the summer and fall to try and find a solution there. We got close. We couldn't find 100% support. So we had Verizon brought this issue forward, and the other telecom members said, yeah, this is an issue that needs to be addressed. Under this bill, embracing for this session, Verizon and the telecom members were looking for a July 1 effective date. Our retail members said that's not enough time. Let's try to find something else. This version has July 1, 2022. The Senate version has January 1, 2022, and the January 1 was to split the difference between where the telecom folks were and where our retail folks were, and we couldn't just leave the effective date of that provision blank. We asked, but we have taken the position among our membership that, you know, it's 6 months difference. We're leaving it up to the legislature to decide what effective date to put in place on the 911 piece. We did all we could to get support and understand it is a fairness issue, just like the sales tax deal, but it's not something that we have full support on. Understand the concerns from both sides. That, you know, I think the liability concerns is the driver for the telecom members, but some of our retail members that, you know, they're pretty much operating on their online stores in every taxing jurisdiction in the country, and they have to get their software up to date to get this in place. And the 911 piece is relatively new. I think, if I remember right, and I'm not sure if John's speaking to the committee today or not from Verizon, but I think it was Vermont was the first state to do this, so it's coming, but it's not quite fully adopted nationally yet. So on that note, with 911 fees, there's another House bill that's in this committee that I believe was the Governor's Tax Council recommendation on the marketplace facilitator. That I haven't read closely that language. I think it's largely based off of what's been introduced in the past, that introduced and had language dealing with other taxes and fees. Our folks are concerned that that type of language is too broad and would potentially encompass many, up to over 40 other taxes and fees that the department could, at a whim, say you were responsible to collect without really any direct statutory authority. The rule that was issued in August of 2019 went into effect October of 2019, does not have that threshold. There was the debate yesterday on the Senate floor over similar language to that without a threshold, and I think Senator Warren, if you go back and watch the Senate floor debate of Senate Bill 22 last night, Senator Warren did a really good job explaining why a threshold is best. So I think it's dealing with somebody who might be in Minnesota, has an Etsy store or whatever, and they literally have $10 worth of sales into the state. It's the burden for that small business that the Supreme Court was looking at. How many points of contact do you have in order to have a presence within the state? So I think the NCSL model language we would prefer. It does have support nationally from all the interested parties. We did try to be proactive and come to a solution on the 911 piece to the best of our ability. Again, that is different from the Senate version, but we'll leave it up to you guys to figure out which is the best approach. So all that said, I will wrap up. I'm happy to answer any questions at the appropriate time, and we would just ask for your support for House Bill 2173.
Thank you. Committee will go ahead and take questions now. Do we have any questions for Mr. Stafford? Representative Wassinger.
Thank you, Mr. Chair. I think this does level the playing field for our small businesses in downtown Kansas, small towns in Kansas. I know that in prior years, and it was I believe it was 2537. No wonder you could transpose the numbers and almost get the same number. There were many different options that we discussed, one being taking that revenue. I have some heartburn just putting it in the state general fund without directing it to be somewhere such as starting to lower the food sales tax. I know that that's not something that Representative Gardner thought that was appropriate because it didn't take it all the way. But I think we have to start somewhere. Do you have any suggestions as to how we would specify these funds? Thank you, Mr. Chairman.
Yeah, you know, our preference is that this policy be revenue neutral. I will tell you that the bill is drafted this year not revenue neutral, in the hopes that we could have a decoupling bill that doesn't have a significant fiscal note that maybe could potentially use to help pay for that, and help the second floor think that it's a good idea. So no, those are the conversations that we've had with the governor's office, that that's why we didn't draft it this way, is what our hope was. I don't know if it's enough or not, but that was what we did. So we might need 3 internet sales tax bills to pay for what they did yesterday on the floor, though, and I don't know how we'll do that. So yeah, if that answers your question, at this point it's not drafted to be revenue neutral, just so we could try to offset the decoupling fiscal note with revenue from this.
Okay, thank you very much. Thank you, Mr. Chair.
Further questions, committee? Seeing none. Eric, thank you for your testimony.
Thank you.
Our second proponent, I'd like to welcome to committee Natalie Bright with the Travel Industry Association of Kansas. Welcome to committee.
Chairman Smith, honorable committee members, I am Natalie Bright here on behalf of the Travel Industry Association of Kansas. We are the tourism professionals throughout. We're here to just say yes to what Eric just said. We want to level the playing field. Where this comes into play for third-party marketplace facilitators is lodging and those types of things, and we want to make sure that they're collecting the sales tax and the transient guest tax that is collected by your brick and mortar facilities here in Kansas. I do have in my testimony one particular amendment we would like to have based on the definition in the bill, and it used lodging establishments, and that would one would think that would collect all of them, but in the definitional section it's actually creating an exemption, and so that exemption is broad, that language is broader, making the exemption broader than what I think the intent of this bill is, and so we would just ask that it be changed to hotel, because hotels are already required to collect it in the state, and so we wouldn't want to put a double requirement on them. So it's just different. Typically, we don't do exceptions in our definitions, and this was written with a definition. So it's almost like a double negative. And so what we're just saying is we need to make sure that exception or that exemption is the intent to be the narrower, to exempt the hotels from having to facilitate this. I hope I haven't confused you too much. But it really was just a drafting. I think this was model language, and when we initially looked at it, Eric shared it, we thought it was fine, but then when the attorneys looked at the actual definitions in the state, that's where the confusion came in, so they recommend that we do hotel as opposed to lodging.
Thank you. Committee, any questions? Representative Highland.
Thank you, Mr. Chairman. Has that amendment been sent down to the revisers?
Not yet. I have talked about it. We did it. There was a similar bill that we requested the same amendment on Senate Bill 50. We have not prepared that, but I have spoken to Eric and cleared it with him. I don't want to speak for him, but he did not have any issues when we brought that forth.
Where is that in the bill?
I apologize. I tried to go get a copy of 2173 on my way up, and I just missed the bill office, so I can't give you, but it's in the definitional sections. I apologize, I can't get you I don't have a copy of it. Oh, Eric does, thank you. So it would be on page 1, line 22 in that marketplace facilitator definition. It starts at line 22 on page 1.
Thank you very much.
Committee, any further questions? Representative Gardner.
Thanks, Natalie. With that amendment, I'm trying to read through there, but would this include bed and breakfast, VRBO, if I rent a house for a period of time via VRBO or home away, would they have to?
That is what we believe the intent of the bill was.
Right.
But because there's an exception or an exemption created in the definition, it would exempt out that broader group, and we want to collect from that broader group, because we think that's where the inequity is in the Main Street, and where we would want to level the playing field for our brick and mortars here.
Okay, thanks, Natalie.
Any further questions? Seeing none, Natalie, thank you for your testimony.
Appreciate the opportunity.
Our next proponent is Trey Kawking with the League of Municipalities. Welcome to committee, Trey.
Once again, Mr. Chairman, thank you for having us here. We view this as Main Street fairness. Your folks in your hometown, they have to pay this tax. So the folks they're competing with, it only makes sense to us that they should pay it as well. I will say this tax is already due under Kansas law. This is not a new tax. It is due. It's line 19 on your K-40. It is required that you pay it. I am pretty sure I'm one of the few people in the state that pay it. But I have once again taken the pain of analyzing my Amazon purchases for this year to see how many Amazon purchases I made. I will say that they were up. I had made 106 in 2019. In 2020, I made 244 Amazon purchases. My wife and I might need to have a conversation about my purchasing, but of those 244 transactions, 74 were not taxed. So about 30% of what you buy on Amazon is not taxed currently. This would get that. And then, shockingly enough, when I made those 106 transactions in 2019, 32 were not taxed, right at that 30% rate. So about 30% of Amazon transactions are not being taxed right now. 70% are, at least anecdotally from what I can see. The other thing I will point out real quick is just the growth in online sales tax, or online sales. In 2014, on Cyber Monday, $2.65 billion was what the sales was on Cyber Monday. In 2020, it was $10.8 billion. So a five-fold increase in online sales on that one day in the last 6 years. So we think this is very important for Kansas communities. Give them a fair shake. It's already due, so we would urge you guys to pass this bill and put it into effect as soon as possible. Stand for any questions.
Thank you. Trey, I have a question. Where do you take a position on the threshold dollar amount? How does that affect your communities?
You know, at the end of the day, we want this in place. Yeah, a lower threshold sounds great, but I don't want the lower threshold to derail a bill from getting in place. And the most important thing is we pass the bill. At the end of the day, that is the absolute most important thing. And then after that, you know, that's up to you guys what that threshold should be. I mean, you know, I've seen you guys pass bills. Hey, we don't mind getting sued. Let's try something novel. If you guys want to take that approach, that's fine. But you guys know the $100,000 number is a safe number.
Representative Baker.
Thank you, Mr. Chairman. Thank you for your testimony. So you'd be okay if we gave the $100,000 threshold to all the bricks and mortar structures also?
What we know is that we know what is legal now.
Right. If I could get you to speak into the microphone, that way we can.
Yeah.
I know it's really easy to turn around and.
It's really easy. Yeah. We know what's legal. We recommend, you know, we just want something that's legal conformity at the end of the day. I mean, obviously that's a policy decision if you guys want to increase it for in-state folks, but, you know, there's a definite cost to that.
So I don't think there is a threshold for in-state folks. I think it's first dollar, every dollar. And my question is, fair and equitable? I think that's a pretty serious responsibility we have here, is to pass laws that are fair and equitable to our groups. Treating out-of-state people differently than we treat our own bricks and mortar, that doesn't pass the smell test in my opinion, but whatever. Thank you.
Representative Gardner.
Thank you, Mr. Chairman. Hey, Trey, thanks for being here. Give me a guess. What would this bill do for locals, munis, from a local taxing standpoint? How much revenue do you anticipate or project? No, we had a number a couple of years ago, if I remember correctly.
Yeah, and you know, it's been made more difficult by the enactment. But, let's think, if it's 30% of Amazon sales, I don't know how, I'm guessing Amazon is the largest vendor in the state of Kansas. That goes, obviously I don't have that confidential information, Department of Revenue does, but if you're increasing Amazon sales by 30%, or sales tax, that's a pretty buoyant number. I will tell you is, I've spent a lot of time analyzing local government sales tax this past year with COVID, and it has been the compensating use. It has been, thankfully, we've been able to capture a lot of these dollars, or our cities would be really hurting. But, I think it's probably somewhere between a 20 to 30% increase on that compensating use number.
Okay, thanks.
Committee, any further questions? Seeing none in the room and none online, thank you for your testimony.
Sir.
Committee, that is the only oral proponent testimony. Is there anyone that I've missed that wishes to appear as a proponent? Seeing none, I will address your attention to written-only testimony as proponents. Brian Huseman, Vice President of Public Policy for Amazon, Stuart Little with Little Government Relations, and Mark Manning, Finance Director of City of Wichita. We will now move on to our, no, we won't. Opponent testimony. I show nobody appearing as an opponent. Is there anyone that wishes to appear as an opponent? Seeing none, we will move to the neutral testimony. And I would like to welcome to committee, I'm going to butcher this and I apologize, but is it John Smellick?
Yeah, that's
Director
really close. Thank you. Feel free, please, though, to call me John.
Will do. Thank you. Welcome to committee, John.
Thank you, Chairman Smith and House Tax Committee members. I'm John Schmalak. I'm the State Tax Policy Director for Verizon. And my testimony is marked neutral, but really this is a very, very good bill for Kansas and for the general business community because it creates parity in the collection of sales and use taxes for every distribution channel, bricks and mortar, online retailers, and marketplace facilitators. But the reason my testimony is marked neutral is because we at Verizon believe in full parity, not just with respect to the sales and use tax, but also with respect to all other taxes, so as not to give one company or one distribution channel a competitive, unfair advantage over others. And so what I'm going to talk about is the prepaid wireless 911 fee that was enacted in 2011 in Kansas. This fee is paid by Kansas consumers of prepaid wireless service, and it's collected by sellers at the point of sale. Back in 2011, when this Kansas 911 prepaid law was enacted, the marketplace facilitator transactions were not as commonplace as they are now. And so today, current Kansas law is unclear whether marketplace facilitators like Amazon and eBay, whether they must collect a 911 fee on prepaid wireless sales. Last session's bill, as Mr. Stafford mentioned, would have fixed that loophole and made everybody collect and remit it uniformly. However, COVID kind of got in the way. And so, so in the interim, as Mr. Stafford mentioned, he assembled conference calls with the telecom industry and with retailers and marketplace facilitators to arrive at a workable date. And the date that was agreed on on the first conference call in October was January 1st, 2022. That's the same date that's in the Senate bill, SB 50. And that's the bill that Verizon favors. There's actually 3 bills, okay? And Mr. Stafford mentioned them, but they all have different effective dates in Kansas. The Governor's Tax Council proposed HB 2225, and that has an effective date of July 1st, 2021. And then there's this bill, HB 2173, that has effective date for prepaid 911 of July 1st, 2022. What I would recommend to this committee for their consideration is the compromise date of 1/1/22 that's in SB 50. That splits the difference between the Governor's Tax Council and the date that it's in this bill. And just one more clarification, when we got together on a conference call in October, we ended that call in agreement to use the compromise date of January 1st, 2022 for prepaid wireless 911. Subsequently, there was only one company that wanted a later date, and that company is Amazon. BestBuy.com and Walmart.com, two marketplace facilitators, agreed to the compromise date of January 1st, 2022. So also, Mr. Stafford mentioned that well, I think he said Vermont, which is correct, but there's actually 2 states that already require marketplace facilitators to collect the prepaid wireless 911 fee. That is Vermont, and that effective date is July 1st of 21. And Washington has had their prepaid or their marketplace facilitators collect the 911 fees since January 1st of 20. And we're wondering in the telecom community why Amazon can't port that functionality in their marketplace facilitator system to Kansas and other states. Why they need so much time to implement in Kansas when it's already in effect in 2 states. As you know, this 911 money is critical to Kansas communities. All distribution channels should contribute equally to 911 through their customers. The funding's too critical to give any favoritism or competitive advantage to one channel over another. I'd encourage the members of the committee to please consider January 1st, 2022, so Kansas doesn't favor one sales channel over another. And I thank you, and I stand for questions, Mr. Chairman, at the appropriate time.
Thank you. Committee questions? Representative Gartner.
Thank you, Mr. Chairman. John, thanks for your testimony. This would be new revenue flowing into our 911 coffers, correct?
Yes.
Go ahead.
As far as the marketplace facilitators, yes.
Right. Do you have any idea how much revenue we might be talking about on these prepaid 911 fees?
I would urge you to ask and direct that question to the marketplace facilitator, since they have complete control over those transactions. I wouldn't know.
Okay. Thank you.
I might turn to Department of Revenue. Is that a number that the department has tried to parse out of the fiscal note? Any monies directed to the E911 fees?
Mr. Chairman, no, we have not tried to parse that out.
Okay, thank you for that. Committee, any further questions? Seeing none, thank you for your testimony, sir.
Thank you.
Committee, I do not show anyone else testifying neutral orally. We do have several written testimony as neutral. Molly Boyle, President for AT&T. Patrick Fusick, Director of State Government Affairs, T-Mobile. Also have John Smilak and Emily Fetch, Director of Fiscal Policy, Kansas Action for Children. Is there anyone else wishing to appear neutral on House Bill 2173? Seeing none, we will close the hearing on House Bill 2173. Committee, I would like to turn our attention to Senate Bill 13. Open up debate in working Senate Bill 13, and I would first turn to the Revisor's Office for a brief overview.
Thank you, Mr. Chairman. Senate Bill 13, if you may recall, relates to property taxation. The bill will establish the new notice and public hearing requirements for any governing body who would wish to exceed its revenue neutral rate, which would be a new term defined in the bill for property tax purposes. It would discontinue the current city and county tax lid. Currently, the bill has both of them. The tax lid discontinuing and this new provision going into effect January 1 of 2021. The bill would prohibit valuation increases of real property solely as a result of normal repair, replacement, or maintenance of existing structures or improvements. Lastly, the bill would also provide the county treasurer the authority to establish a payment plan for the payment of delinquent or non-delinquent taxes. And with that, I'd be happy to stand for any questions.
Thank you, Mr. Siebers. Committee, questions for the reviser? Seeing none, whoops, let me check online. Seeing none, thank you for that overview. Committee, what are your wishes with Senate Bill 13? Chair recognizes Representative Mason for a motion.
Thank you, Mr. Chairman. I move that the committee would recommend Senate Bill 13 favorable for passage.
We have a motion by Representative Mason, second by Representative Wassinger. And we are open for discussion. And committee, I would like to be the first guinea pig here just because we have kind of a different process for amendments. So Adam, I would like to propose an amendment. It's the publication notice amendment. And we should be receiving that via email. If you are in the committee room and you need a paper copy of that amendment, go ahead and raise your hand. Our committee assistant is available to pass those out.
Mr. Chair, just so I can check, is this the amendment you were describing up on the screen that I'm sharing?
Yes, that is the one. We are just about to get it distributed. Does everyone have a copy that needs a copy? I do want to, we do have a couple of members out there online. Do you have access to that? Did you receive the copy of the amendment? I'm seeing nods and thumbs in the air, so I think we're good. Adam, would you care to give a brief overview of the amendment?
Sure, I'd be happy to. If you give me 1 second, I'll email it out real quick and then we'll proceed. Okay, sorry. Yes, the amendment that states publication notice up in the right, the box in the right-hand corner. If you look down into new section 1, subsection B1, makes changes to the notice requirements. In addition to the current requirement, which requires the notice be published on the governing body's website, there would also be a requirement that the notice of its intent to exceed, the governing body's intent to exceed the revenue neutral rate be published in a weekly or daily newspaper of the county having a general circulation therein. And that would commence January 1 of 2021. The second part of the amendment would be for the individual notice provisions, which are found in B2, where each individual taxpayer is mailed a individual notice. Essentially, that provision would be delayed by a year, so everyone getting their individual notices, that would start kicking in for tax year 2022. So that would delay the provision by a year. And with that, I believe that's the contents of the amendment.
Thank you, Mr. Siebers. Committee, are there any questions for the reviser? Seeing none, I apologize. I need to call for a second on the motion. Second by Representative Mason. Okay, we are on discussion. I would like to just briefly explain. This is an amendment that I worked on to try to keep the implementation date in 2021, but yet effectively what this does is it pushes back the notification requirement that the county clerks have such concern that we were all getting the emails about the programming, getting everything up to speed for this year. This pushes all of the detailed notification requirement in that subparagraph 2 back to 2022. This is a compromise trying to get the bill implemented rather than, we heard a lot of testimony on just pushing the full implementation back to 2022. I actually heard a lot of out in rural areas, small counties in western Kansas, the tax lid has not been effective and they really need some relief from that. They would like to be able to implement this year and try to work through that. So this was a compromise to get the full bill implemented with the exception of that notification. And I would stand for questions. Representative Potter.
Thank you, Chairman. First of all, I wanted to say that I like this solution because it keeps the effective date basically, and that way we don't have to have the tax lid in place for an extra year by changing it. I was just curious if you knew what the fiscal note on the newspaper publishing requirement versus the mailing.
I did not get a fiscal note on the publication notice. Essentially, all it was, counties already have to do the budget notification, publication. It would be much smaller than that. It literally would just have to show the revenue neutral rate, their intent, the proposed rate, date and time and location of the hearing. So it could be a relatively small. It would not be nearly as large as those legal notices that you see in the newspaper for the budget.
Thank you, Chairman.
Representative Sanders.
Thank you, Mr. Chairman. So just to clarify, would this simply delay the mail notification till December 31st or January 1st of 2022, or would it eliminate it, replace it with the other things in this?
What would happen is this year, all that is required is a publication in the newspaper, and it's included in section 1 there where you have the requirement for publishing in the newspaper and also on a website if the county maintains a website, which I visited with a representative from Kansas Association of Counties. He said every governmental entity, every county maintains a website. Now, whether it's updated frequently, that's another thing to be said. But those two requirements go in. The notification requirement will basically take effect in 2022 for that budget year. So we're talking about, the July 15th of 2022, that's when this process will start.
So it would still have to be mailed at that point?
Yes, that's correct. But counties would have time to budget for that in this year's budget and be able to prepare for that if they did have to make that mailing.
Thank you, Mr. Chairman.
Representative Corbett.
Chairman, how does this do it? Does this allow the county to give them a year to raise their taxes without notifying or having a hearing?
No, they still have to have the hearing. The revenue neutral rate is still implemented. The only thing that changes is that required mailed notification, the detailed statement. They still have to have the hearing. They still have to publish that in the newspaper and publish it on their website if they have it. So the hearing will still have to happen. The vote, the ordinance, the resolution will still have to happen. Representative Wassinger.
Thank you, Mr. Chair. Where does it say that? I just want to make sure that's in there. I know that we were worried about that, that the why, one of the big reasons why they didn't want to delay the mailing was because they wanted to make sure it stayed, they took the tax lid off and did the net revenue neutral. Where is, can the revisor or someone tell me exactly where that is and remains in the bill? Maybe I'm just not looking at it correctly. Thank you, Mr. Chair.
Certainly. Adam, would you prefer to address that? I don't have the full bill right in front of me right now.
And I may have missed the first part of the question, the provision that we're referring to, under the amendment.
Thank you. Is it the first paragraph that delineates that? And so I just wanted to make sure that that's in there and we're not missing something.
Okay, I think I understand now. On page 4 of the bill, under section 1, the very last provision, the very last section, subsection G, all the contents of the bill goes into force and effect on January 1 of 2021. So the overriding principle is the bill, this section is essentially retroactive to January 1, 2021. Statutorily or bill drafting wise, then we have exempted out essentially the individual notice by having under B2, a specific reference to another date, which would be after a certain day. So all the contents of the bill go into effect for this current year, 2021. The specific provision in B2 only kicks in the following year, if that makes sense.
It does. Thank you very much, Mr. Chair.
Thank you, Mr. Siebers. Committee, further questions? Representative Everkamp.
Mr. Chairman, so if I can recall correctly, back during the hearing, there was a comment made about pushing off the notification requirements to the following year, so 2022 start date. I think there's also a comment about leaving the tax lid in place for 2021 as well. During the delay. But as I'm reading this both delays it and also eliminates the tax lid. Is that correct?
Yes and no. It does delay just the notification, the revenue neutral rate, and the hearing that has to happen because of that part of this new transparency policy is still enacted. The only thing that is pushed back is that detailed notification, basically your tax estimate that you would receive in the mail before that hearing. The hearing still has to take place. The revenue neutral rate is still calculated and distributed. If they exceed that, they still have to provide this notification on the website and in the newspaper of the hearing date. And the tax lid is repealed this year. Representative Potter.
Thank you, Mr. Chairman. Just to clarify on that, if somebody was curious about how the increase would impact them, would they have the ability to directly contact the county clerk for that information?
That would depend on their valuation and how that rate would impact them. Now, the problem that we have is the programming that would be required at the county clerk's office to produce that statement would not be in place. So it would take a hand calculation based on all of the tax entities, the county, the city, schools, fire districts, whatever districts you have on your tax statement. You'd have to look at those, each one of those levies and apply it to your assessed valuation to get that estimated tax bill. I'm not sure if any clerk would feel comfortable doing that.
Thank you, Mr. Chairman.
Any further questions, committee? Representative Wassinger.
Sorry. And I'm not sure, Mr. Chair, if you were in the legislature when the tax lid was enacted. Being a county commissioner as I was during that time, I remember the discussions being before this tax lid gets implemented, maybe we should really raise the mill levy. And I'm sure that many counties had that discussion. before the tax lid was put on. I don't think very many did. I don't have any records to say whether they did or not. But I know that one of the problems that they anticipated was if we waited to implement revenue neutral, the counties would raise their mill levy in the next year. And I haven't gotten emails on that, and I believe that the counties would be better than that, most of them. But I just wanted to point that out, that that's one of the reasons why it's being implemented immediately.
Committee, any further questions? I apologize, I've not had my computer up here to see if there's any questions virtually. Not seeing any. Representative Turner?
Thank you, Mr. Chairman. So, listening to Representative Wassinger's comments, I'm curious, because you asked the question earlier about a delay of the implementation. I thought I heard that is not delayed, right? It's just a notification that is delayed. So the concern that you expressed is not, okay, good. I just want to make sure I was tracking correctly. Thank you. Thank you, Mr. Chairman.
Any further questions? Seeing none, I will close on the motion and call for a vote. All those in favor of the amendment, please signify by saying aye.
Aye.
Opposed? The ayes appear to have it. The ayes do have it. Motion is adopted. We are back on the bill. Discussion. Representative Kelly.
Thank you, Mr. Chair. I have an amendment that concerns the cost for the taxing subdivisions. We got a number of emails on that about from the library district, and I have one that I believe that should be a fair way to do it based on their size, and I believe Leah has a copy of it, and Adam would have an explanation of it.
Mr. Siebers, would you mind explaining the amendment while Leah passes out the language?
Yeah, sorry about that. Representative Kelly, is this the correct one? Just so I'm on the same page. Deal with the payment of the notices, right?
Yes. Is there a way you could enlarge that a little bit? It's difficult to see on the TV in here.
Apologize. Then the front page says payment of notices, I believe. And then the second page.
Does everyone have a copy of the Kelly amendment? Looks like we're ready to go.
All right, very good. Sorry about that. If you don't have it, you should be receiving it by email. I just sent that to everyone. Okay, what this amendment does is it would amend the current structure for how the notices that will go into effect next year, January 1 of 2022, how they would be, the costs for those notices would be borne. Currently, the printing and postage for the notices is shared equally by all taxing subdivisions. If you can see from the amendment, the language changes the shared equally to proportionally, and it's based on the total property tax levied by each jurisdiction. So instead of an equal sharing of cost, the size of the taxing jurisdiction would proportionately bear the cost of the notices. And with that, I'd be happy to stand for any questions.
Thank Thank you, Mr. Severs. Committee questions for the reviser? Representative Corbett.
So Adam, how would this actually happen? If we're going to do a mailing, how do you determine who's going to pay what and how much? Am I missing something?
Could you hear the question?
So Adam, the question I have for you, on this amendment, how does that affect proportionally for postage and mailing for subdivisions?
It's done by the property tax levied by each subdivision. So you take the total property tax levied and then take the proportion of that tax that was levied by, say, the fire district or the library district. So
the
would be paying on their property that they had the increase on.
So the more they tax, the more they pay?
The bigger the subdivision, or the bigger the jurisdiction, the more postage and all they would likely pay, yes. I mean, a city would pay more than a library district or maybe a fire district.
Regardless of whatever the mill levy was or whatever the tax increase was for the subdivision, this would be the way it'd be mailed out.
This is the way the postage and mailing expense would be. If one of them had to send out a total of 50 letters, it would still be based on the proportion of their total tax levied to the total of the district. I mean, to the total of everyone in the county.
Representative Highland.
Thank you, Mr. Chairman. So what we've been hearing is the schools have in general between 30 and 35% of the total property tax, and the county 20 to 30. So that would be their proportion of this, the way you have it written.
Yes, based on the tax levied, the county, they would pay 20 and then the other would pay 30% of the mailing.
Can we do that to the schools?
I might turn to the reviser, but the schools are actually exempt from this provision of the bill.
Yeah, I want to make sure everyone's clear. The schools are exempt, so they just so no one's confused, they won't pay anything ever under the bill because they're exempt from the provision. So it would be, if you want to use cities, counties, some other sort of taxing subdivisions, but schools are totally exempt from having to pay any sort of costs underneath the bill.
It's nice, thank you.
Any further questions for the reviser? Representative Sanders.
Thank you, Mr. Chairman. So just so I understand, there would only be one mailing that would go out that would, other than the schools that are exempted for whatever reason, that there would only be one mailing that would go out that would cover all of the taxing entities within a county?
That would be correct when they went to figure out the cost of the mailing of this notice. The county who would be in charge of mailing the notice would go back and they would calculate how much they were going to bill the library district based on the proportion of tax that they levied. So they would go in and send the library a bill for that amount, and they'd send the cities in the county a bill for their amount, and they would pay proportionally by how much tax or the levy that they had. So a smaller district would not end up with a larger bill just because they divided it by 12 instead of figuring out who was the largest one down to who had just a minimal amount. So some way to make it proportional and fair to each one of them.
Thank you, Mr. Chairman.
Committee, we're getting a little ahead of ourselves. We need to just target our questions to the reviser. If we are done with questions for the reviser, we will need a second on the amendment, and then we can begin discussion. Is there any further questions specifically for the reviser? Representative Highland.
Thank you, Mr. Chairman. As I understand this, and the bill says the schools are exempt, so this proportionality would have to include then that 30% the schools, so you have to divide their 30% among all the others. Is that correct, how I understand it?
I believe you may be, it's 30% of the cost of the mailing, not 30% of all taxes levied. So, they figure out the cost that it's going to cost, I'm guessing, for, mailing and postage and printing of these notices. Then all of the different taxing bodies who are, going to exceed their revenue neutral rate, they would figure out their proportional, levy to the cost of the mailing. So I don't know if that clarifies or not, but I believe that's how that would work.
Thank you, Mr. Chairman.
Questions for the reviser, Representative Kessler.
Thank you, Mr. Chair. Just really quick question. If for some reason that the city decides to raise revenue but the county does not, who pays that?
If there's only one unit that will be raising their property tax, for that jurisdiction, it would be 100% borne by that one unit is how I would interpret it. That would be anyone that would be exceeding the revenue neutral rate. So if other entities don't exceed their revenue neutral rate, they wouldn't have to go through this whole process. So they would be wouldn't have to bear any costs for printing the notices.
Does that satisfy your question? Okay. Any further questions for the reviser? Seeing none, thank you. Oh, we do have a question, Representative Turner.
Yes, thank you, Mr. Chairman. Just to look at the language here, so it looks like there's two things being done. Number one is instead of cost associated, it's now specifying printing and postage, correct? That's just clarifying what's involved or associated with generating the notice? Is that
it does amend printing and postage to printing and mailing, and as a technical change, the above line printing and postage would also be adjusted to printing and mailing.
all right? And then secondly, it's concerned with changing the word equally to proportionally, and then giving explanation. So that's the two big things happening here, correct?
That's correct.
All right, thank you.
Representative Wassinger.
In the off chance that every taxing district decides that they want to raise their tax rate, that proportion doesn't come up to 100% because of the schools. So then they would all have to bear the school's cost, correct? Maybe I'm not doing the math correctly. Thank you, Mr. Chair, sorry.
And it really, I agree, but my interpretation of it would be that they would only take into account the ones who would be liable for the tax. I mean, I understand that there will be certain things printed for educational school districts. I know there's certain information. However, they won't be on the hook for any sort of costs associated with it. So it's my belief I believe it's the treasurer who prints these would take into account just those entities who would be on the hook, look at their budgets, compare those proportionally to them, apportion the cost for the mailing and notice, and would leave out the ones, the state and then the school districts who have information that will be included on the notice, but won't be charged any sort of cost for printing the notice, if that makes sense.
Committee, if you would look at, I think it's page 3 of the bill. This is not on the amendment. This is on the bill. Page 3, under it starts at line 23, subsection D. That is where it defines that the provisions of this section, we're talking about section 1, this entire first section, those provisions do not apply to school districts. Therefore, even though once the detailed notice is required, the school's information will be included on that, but they are not subject to paying for the postage and printing costs. They are not subject to holding the hearing or voting on the exceeding the revenue neutral rate. They will still have to hold their statutory budget hearing that all tax subdivisions do already, but they will not be included in those provisions of the bill. Do we have any further questions for the reviser? Representative Awerkamp.
Sorry, Mr. Chairman, just clarification on something you just said. The notification sent out would include the information from the school. If the schools are exempt from new section 1, new section 1 requires all governing taxing entities to submit their information to the county clerk by July 15th. But the schools are exempt. It appears that, am I correct, those schools have a choice on whether or not to submit their information in time?
I would have to turn to the reviser on that, because that is a good point on if they comply with the July 15th date. Is that what you're talking about, to where they notify the county clerk?
Yes, Mr. Chairman, on page 3, where it says the provisions of this section do not apply to school districts, reading this section as section 1, and in section 1 is the requirement for July 15th. Other than that, I think they have until, is it October 31st to submit information to the county clerk, maybe?
Yeah, that section D, the second sentence says, notwithstanding the foregoing sentence, the county clerk shall provide the school district information when complying with the county clerk responsibilities pursuant to this section, including but not limited to that subsection B2. So it's my reading and understanding that they will still have to provide that information for the revenue neutral rate. So because ultimately the notification is intended to be a tax bill estimate. So we need the information from the schools on that estimate, so taxpayers will know approximately what their tax bill would be.
Thank you, Mr. Chairman. Sorry about that.
Any further questions for the reviser? Seeing none, is there a second on the amendment? Representative Gardner for the second. Committee, further discussion on the amendment. Representative Highland.
Well, just open up a can of worms. None of the taxing agencies or groups are going to exceed, except for the schools. So who pays for that in that instance?
That might be a question for the reviser. Since the schools are exempt, would that statement have to go out if no other tax entities increase their above and beyond the revenue neutral rate?
Mr. Chair, I would concur that if no other entity is liable or, is going to be exceeding the revenue neutral rate, the information would not be able to be attached to the notice, so there would be no notice for that information to go out to it. The provisions do somewhat assume that, there will be other entities, every jurisdiction is covered by multiple taxing authorities. However, if no one does exceed their revenue neutral rate, there would be no cause for the printing and postage by the school, or for just those entities that are exempt. So I don't see why it would be. It's a little bit left unclear, but I don't see why that the clerk would send out a notice if no other entity would be on the hook for raising a revenue neutral rate.
Thank you, Mr. Chairman.
Any further questions? Representative Potter?
Chairman, was the school exempt from the tax lid?
The tax lid only applied to cities and counties.
So the means by which the schools notify of taxing increases would not change with this bill? Okay. Just wanted to clarify that. Thank you.
See no further questions. Representative, you may close.
Thank you, Mr. Chair. I close.
Committee, you've heard the motion by Representative Kelly to amend. All those in favor, please signify by saying aye.
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 Any opposed? Motion carries. We are back on the bill. Committee, discussion, or amendments? Representative Averkamp.
Mr. Chairman, have an amendment. It's available to pass out. I appreciate that. It's the $100,000 budget exemption amendment.
Representative, do you want the reviser to explain your amendment, or do you want to proceed?
Thank you, Mr. Chairman. I'll give it a whirl. I'll give it a shot here. So the amendment simply refers to taxing entities other than cities and counties. And that's mainly because of a home rule question that came up with the reviser on how that applies to, we couldn't exempt out certain cities and not the others. So this specifically goes after the small taxing jurisdictions of townships and cemetery boards and different ones like that. Speaking with county clerks in my district, a lot of these boards have volunteers on them. They're very small. Their budgets are very small. Sometimes their budgets go up a little bit. Sometimes they go down, but overall, they're not a significant number on the tax burden, but because their budgets are pretty tight to begin with, they often will have to go up each year because of the cost, you know, of whether it's gasoline or from mowing or different elements of road care. And a lot of times these mailings will, it's a small amount, but it does add up. And from my perspective, I think they would actually have to add a line item to their budget for mailing notification every year. And talking to people about the bill, often it's referred to larger counties or larger cities. That seems to be the concern of an ever-growing property tax burden, and it's not really these small entities. So I think it's prudent to exempt them from the requirements of this bill. And I would stand for questions, Mr. Chairman.
Okay, committee, do we have a second on the Averkamp amendment? Representative Helgerson with the second. Committee, any questions? Representative Highland.
I'm not trying to be a smart aleck, but does this mean that one of these smaller subdivisions can raise taxes by $100,000 in 1 year and be exempt?
No, Representative, it's not that they can raise taxes by that amount. It's when their total tax revenue is less than $100,000. These small township boards or small taxing entities, it would allow them to be exempt from the requirements.
I understand the intent. It's just sometimes you read these and you wonder. Thank you.
Representative, what another way to say that is if they had a total budget of less than $100,000 from ad valorem tax, they would be exempt from this bill?
Yes, Mr. Chairman.
Thank you. Representative Blex.
Thank you, Mr. Chair. Would this amendment negate some of the previous amendments we passed in terms of notification when we're talking about if they're less than 100, if they receive less than 100,000, are they going to be somewhat exempt from these other issues? Am I thinking that correctly, or am I wrong?
Thank you, Representative. So I think by them being exempt, it would exempt them from, so I'll ask the revisor. I know it exempts them from participate in the paying of the mailing, but as far as them submitting their budget information to the county clerk, that was part of my intention, partly because a lot of these small boards, they're volunteers, they're farmers. To hit these deadlines is very difficult. It's also difficult on the county clerks who have to track them down, and the county clerks are often the ones working on their budgets, and this is right at the same time that the county clerks are preparing all of the advanced ballots, going out for the primary elections, and doing a lot of other duties. It's a lot of burden. And so, for instance, one county clerk in my district, I think she said she does, I can't remember the exact number, but it's over 10 budgets for these small townships. And if she has to knock all those out by July 15th, it's a lot of effort for her and her staff while they're trying to prepare for elections, and especially elections which there seems to be an increasing number of advanced ballots going out. That was my intention, is to exempt them both from participating in the cost of the mailing as well as the time limitations.
If I may follow up, I guess sometimes those small tax districts can have 80, 100% increase. And even though they're small, I guess I thought the intent of Senate Bill 13 was to provide some transparency on tax increases to the public. And here we are exempting a small group. And yeah, I understand your concept. And I tend to agree with you, but at the same token, I've seen on my tax bills, some of the smaller taxing entities have some huge increases. A small city, for example, that may put in a sewer or something that would raise it a bunch. And, you know, I would like to be notified of that. And I thought Senate Bill 13, that was kind of the intent. Thank you.
Thank you, Representative. So this amendment does not include cities or counties, because of a question with home rule and how that would apply. I was not able to include cities or counties, even though I wanted to, but this simply applies to the other taxing entities.
Representative Corbett.
So basically, I'm understanding this, that no matter what the size of the taxing entity, as long as they stay under 100,000, whether they raise your taxes 50,000, they'd be exempt.
Yes, that is correct. If it's a small township or cemetery board and they, for some odd reason, want to raise 50,000, if their current tax rate or tax amount is 25 and they want to raise it 50, they would still be exempt. You know, most of the small taxing entities in this state would never do that. If they do it, these are typically a local volunteer board. They have a good reason for it, but that's going to be extremely rare, in my opinion. And so rather than putting a burden on, I would say, potentially a couple thousand, if the numbers are correct, small taxing entities for what may happen to a few, I think it would be better to just let the small taxing entities take care of themselves without this state mandate.
I think once the word gets around, it kind of gives them a pretty good field or a pretty good window to play in. They just stay within the framework of the 100,000 or whatever. So I see what you're doing, but it still exempts people. It gives them some pretty good money to play with, and it's still a small group of people.
Currently, if the tax lid applies to cities and counties only, these small taxing entities would have no change from their current status. I understand that correctly. It just doesn't force this burden down onto them.
Committee, any further questions? Representative Potter?
Thank you, Mr. Chairman. I'm just curious as to why you went with a dollar amount instead of a percentage, because we have so many different sizes of counties.
So once again, this does not apply to counties or cities. It's just smaller township boards, cemetery boards. Why the 100,000? I wanted it higher. I think the bill that did pass last year but got vetoed by the governor had a limit of 20,000, I was told. No specific reason for 100,000. It was a balance. I wanted to go higher. Last year was 20,000. It was an amount that I thought was reasonable.
Thank you, Mr. Chairman.
Representative, I have one question. Out in rural western Kansas, we have several taxing units that are multi-county units. Does this apply to just the tax amount that is within the county? For instance, we have an extension district, State Research and Extension, that has 3 different counties. If their budget is, let's say it's 200,000, but you break that into 3 different counties and it's less than 100,000 per county, but yet their total budget is over 100,000, are they exempt or non-exempt?
Mr. Chairman, I defer to the reviser if I have this wrong, but according to my reading, that the taxing entity, this would be their entire tax amount. So it does not matter how many counties they spread across.
Mr. Siebers, do you concur with that? That's the way I read it. I just wanted to clarify.
I would concur. The language is reference to the political subdivision, the entity itself, regardless of the lines drawn or if they cross into multiple counties or anything like that. It's directed towards the budget amount of ad valorem taxes they receive. So if the cumulative amount would be over 100,000 or more, this provision would trigger, and then they would be counted. If they're under that, regardless if they cross over multiple counties or not, then they'd be under. But it would tag with the entity itself, not with the various lines.
Okay, thank you. Committee, any further questions? Seeing none, Representative, you may close.
Mr. Chairman, I close on my amendment.
Committee, you've heard the motion from Representative Averkamp to amend. All those in favor, please signify by saying aye.
Aye.
Opposed? Motion carries. Committee, any further discussion? Representative Gartner.
Thank you, Mr. Chairman. I have a short amendment. Should be somewhat simple.
You want to explain your amendment, or do you want the reviser to?
Why don't we have Adam explain it? It's pretty simple.
Okay. Okay, Mr. Siebers, I believe everyone has a copy of the amendment.
All right, very good. The amendment itself has the Municipal University up in the right-hand box, right-hand corner of the first page. The changes themselves would be made on page 3 of the bill, which is really the backside of the document you received, just to print off the extraneous page. And what this amendment would do, it would add Municipal University. It would put them on the same field as a school district. So the language "or Municipal University" would be added in 4 places there under subsection D. So essentially the notice provisions, Municipal University would not have to, they'd be exempted similar to school districts. And with that, I'd be happy to stand for any questions.
Committee questions for the reviser? Adam, I do have one question. Do we know how many municipal universities exist in Kansas?
I'm aware of one, but I could be wrong. I'm not 100% certain on that.
Perhaps the carrier of the amendment will be able to elaborate. Any further questions for the reviser? Seeing none, Representative Gartner, you may continue.
You're going to test me, Mr. Chairman. Adam, I might say, I think universities is spelled wrong on the first balloon in the box, if I see it correctly. This basically, there is one municipal university in the United States, and that's right here in Topeka, Washburn University. They have been funded differently since their creation via the Topeka city property taxes, sales taxes, basically. But what they have, they're different. Their board really doesn't have, like we heard, the community colleges where they have taxing authority. Their authority is spelled out in statute. And they have two sources. One is a 3 mill levy cap. It cannot exceed by statute a 3 mill levy. That goes to, I believe, capital, let's see here, it goes to a capital outlay, basically, buildings, equipment, et cetera. And then they have another one that is spelled out in statute that is right now, I believe it's capped at 1 mil. It's right now 1/3 of a mil, which goes for to a liability fund. The other reasoning is they're on a, like the state, their fiscal year is July 1st to June 30th, where most of the other taxing subdivisions are on a calendar year. What I'm asking is, since their mill levies are capped in state statutes, I think they're a little bit different than the other taxing subdivisions we're dealing with in Senate Bill 13. So with that, Mr. Chairman, I would stand for questions.
Thank you. Do we have a second? Representative Highland on the second. Discussion? Representative Corbett.
Representative Gardner, I ran their dates by earlier on Senate Bill 13, and the revisor I talked to said that dates in 13 and the dates they worked their bill, their dates would fall within the bill. I think it's a little troublesome on this. The taxpayer cannot appeal a mill levy. So it means that it looks like to me who would have a chance to, if you wanted to complain about it or talk about it or hear about it, what chance would anybody have?
Representative Corbett, since it's laid out in statute, capped, I think they'd have to change the statute. There's still, even though they would fall under the exemption of schools, they would still publicize just if they exceeded their revenue neutral rate. So it's still going to be published. It's just that they don't really have a total control because of the cap. I mean, they can go up to the cap, yes. But I just think, and maybe you ask a revisor, I know the people that I've talked to that sit on the board say it just doesn't work for them when they put their budgets together on that fiscal year as far as their dates are concerned.
Representative Gardner, I have a question regarding that. If most of our schools operate on the same fiscal year, and they will have to provide their information as far as the revenue neutral rate, they will not have to have a hearing, but their information will still be included. So am I misunderstanding that their information would still be on, because this would treat the municipal universities the same as schools?
Yes, Mr. Chairman. The information would still be on. Now, I'm not sure, I was just looking at the dates on how they calculate, how they put their budget together, and it doesn't line up like school districts, totally. But they have to have their budget approved by the regents prior to July 1st. So that even moves, I think, the date up where school districts, when I was on the school board, we didn't have to have our budget, by the last of August, and then publicized and approved. So, they're still going to have the revenue neutral rate on the notification.
Do they still, is Washburn required to have the budget hearing on their actual budget, the publication that is required in, I believe it's KSA 792929? On the mill levy, do they have to have a budget hearing?
I would think so, Mr. Chairman, but I am not sure.
Thank you. Committee, further questions? Seeing none in the room and none online, Representative Gartner, you may close.
I close.
Committee, you've heard the Gartner motion on his amendment. All those in favor, please signify by saying aye.
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 Opposed? The ayes appear to have it. The ayes do have it. We are back on the bill. Representative Highland.
Question on the last amendment. Do we give the reviser authority to make that minor correction?
Yes.
Thank you.
Committee, I have in light of some of the amendments that have come on, I have an amendment I would like to propose. Adam, this is called the form amendment. We would please distribute this, and I will, while Leah is distributing it, I will briefly explain. Per statute, KSA 79-2929, every taxing unit in Kansas, every property tax unit is required to submit as a legal publication 10 days prior to their approval of their budget a notification. It's a publication form created by the Office of Accounts and Reports that each tax unit has to publish in their local newspaper. What this amendment is going to do is simply add the revenue neutral rate to that publication form. So the taxpayers will be able to see that form, that budget form. All tax units are required to have a budget hearing. And for some of the tax districts that are now exempted out of this bill, this will still require them to have that revenue neutral rate along with the proposed rate. It's a simple, I visited with the Director of Accounts and Reports. They said this is a simple change for them. It would not take much time, but they did need statutory direction to include this in that form for the smaller districts to include. Municipal universities will still have to include this. So the revenue neutral rate will be seen, even if they don't have to participate in the revenue neutral rate hearing. They will still have to answer questions, perhaps at a budget hearing. And that's essentially what it does, unless, Mr. Siebers, is there anything I've missed?
I apologize, Mr. Chair. I believe you summarized it very well.
Thank you. Committee, is there a second? Second from Representative Helgerson. Any questions? Seeing none, I will close and move my motion. All those in favor, please signify by saying aye.
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 Any opposed? Motion carries. Thank you. Back on the bill, any discussion? Representative Averkamp.
Sorry to keep this going, Mr. Chairman. I do have another amendment. This one's called New Growth.
Committee, I just want to double check with Representative Stogsdill and Representative Alcala. Are you gentlemen receiving the amendments?
This is John Alcala. I get him the minute he sends them out.
Thank you.
Same here.
Representative, do you wish the reviser to explain the amendment?
I'll give it a shot there, Mr. Chairman. Thanks. So what the bill does not allow for is an increase in valuation exemption. So it's really just a net dollar increase, regardless of increased valuations, regardless of new growth, new construction. It doesn't take any of that into consideration. If the taxing entity, city, county, raises its revenue brought in by $1, it now exceeds the neutral rate. I can understand the valuation aspect of that, of the bill. But as far as new construction and growth, that does require city infrastructure, city services, and also the cities, and I'm still on a city council, right? We want to pay our employees well. We have an increase in health care every year. We're trying to give them raises for the ever-increasing cost of living we all are seeing. That's important. And one way we are able to do that, even under the tax lid, is because of the new growth, the new constructions, the new buildings, new businesses. And so I believe that is important. Those areas of our state that do see that new growth, they're allowed to benefit from that. And so that is my intention with the amendment, Mr. Chairman. Once again, it still does not allow valuation. It just allows for the new growth, the increased tax revenue from new growth and new construction. It allows the taxing entity to increase their tax revenue from that and not have to send out the notification.
Okay. Do we have a second, committee? Representative Holgerson for the second. Committee, any discussion? Representative Baker.
Thank you, Mr. Chairman. If you have extra growth, would you send it down my way? We could certainly use a little of that. That's not been a problem for us, but we understand your dilemma. It's a good amendment.
Representative Highland.
Thank you, Mr. Chairman. I guess I understand what you're trying to do, but can that not be explained at the budget hearing? That you have new growth, that's the reason it's going up. I guess exemptions, keep adding exemptions, we're going to end up with no bill here shortly. Could you not explain your new growth, which is everybody would love to have, obviously? Can that not be explained at your budget hearing?
It can be explained at the budget hearing, which will take place with the public notice, with or without this bill. Whether this bill passes or not, the public hearing still takes place. The notification still has to happen in the newspaper. The only difference is that if a city or county has new growth, that new growth does allow for increased tax revenue. But they just increase their tax revenue due to that new growth, new construction. They do not have to absorb the burden of the cost of mailing and the administrative costs of the mailing.
Thank you. Representative Epley.
Thank you, Mr. Chairman. And I'm just trying to understand this, the purpose of this, I guess. So this is new growth, and does that continue into perpetuity, all the new growth that occurs, then it's exempt going forward, or is there an expiration time on that? I mean, I'm not sure I quite understand that. So you're going to have all the old growth is going to be subject to this bill, but anything new is going to be excluded?
So the revenue neutral rate is the rate from the prior year. So going forward, the prior year revenue would include the new growth from the prior year. So the next year, if the city or county has more growth, then if they raise their tax revenue just due to that new growth that year over the prior year, they still do not have to send out the individualized notifications. Does that answer your question, Representative?
What does, if I may comment, Mr. Chair, it seems like at some point after 20 years, the flat rate is, nobody's do that because it's all new growth in a community. Is it just an annual thing? I'm just trying to understand this.
It is an each year thing, but I think the main point from my perspective of the bill is to try to eliminate the growth in tax revenue due to valuation increases. And I can understand that. But however, increased revenue due to new growth, I think it's a good thing on many levels. So the county should be able to absorb that into their budget for not normal increases. But if they want to grow their revenue due to valuation increases, that seems to be what is more frustrating to the property taxpayers.
Mr. Chair, I just think at some point this would nullify the purpose of this bill eventually. I mean, at some point in time, it's going to be completely ineffective. But thank you, Mr. Chair. I'm done.
Representative Blex.
Thank you, Mr. Chair. I guess I get back and follow up that same line of thinking that the purpose of the Transparency Act is to, if there is a justified increase from revenue neutral, as I understand it, then that's the purpose of the hearing. And yet it appears that we're bringing all these exemption in, new growth, new subdivision or tax abatement, and, you know, that's not being divided in. So that's really defeating the transparency part of this bill, in the fact that part of it is to inform them, let them sit on the hot seat and defend what they're doing, and then let them suffer the consequences. But if we start all these exemptions, then pretty soon we might as well throw this in the trash now. Thank you.
Representative Baker.
Thank you, Mr. Chairman. The intent of the bill is excellent. And when you're in a community that's growing, that's a different animal than most of us are used to. So I don't want to make it any more difficult on those county commissioners in those areas that are experiencing growth. That's, if you look at the population trends, that's a really small number. There's only 10 counties, 15 counties in the whole state in the last 10 years that have had growth. So this bill's pretty narrowly focused on that group of counties. I think it's a good bill, and I understand the dilemma. My brother lives in Colorado, and they have all kinds of issues with those lids on new growth. So if this will help them, we need to do it.
Further questions on the amendment? Representative Corbett.
As always, this tax committee is always worried about government instead of the victims out there who are writing the checks with more exemptions and more exemptions. It's just like they gripe about doing the mailings. Shawnee County takes in $400 and some million. I will pay for a mailing every Thursday if I can get $400 million. I mean, I'm kind of like the rest of you. It's kind of turning into like 13 light. Just keep giving exemptions. Just forget the bill. Everybody can get their exemptions and go home.
Representative Wassinger.
The exact purpose for this bill was to make sure that counties are transparent in telling people that they've got more money, okay? And the biggest complaint I hear and I see on my son's tax bill in Johnson County is their revenues keep going up because all the growth in their county. And they always, oh, we don't have to, we didn't raise the mill levy. We just got, 500 million more from our new growth. The whole point behind SB 13 is not to punish the people who have new growth. It's to make the people who have new growth explain why they are going to have to up their mill levy to match the new revenue. I can't support this. This is the whole reason behind this bill. Thank you, Mr. Chair.
Any further questions? Representative Baker?
Thank you. I also have real estate in Kansas City, and the problem isn't the mill levy. The problem is my valuation keeps going up on my property, which is a really nice problem because I have property in rural areas. I don't think it'll bring half of what they got it appraised at. So, difference between mill levy and appraisals.
Any further questions? Seeing none, Representative, you may close.
Mr. Chairman, I think the distinction is valuations versus the important point is the valuation. Even if this amendment gets on, it still will catch the valuation increases. This amendment just simply allows new growth and new construction to not add the burden of the mailer to the taxing entity.
Okay, committee, you have heard the amendment by Representative Auerkamp. A roll call vote has been requested. All those in favor, please signify by raising your right hand. Please keep your hands up just so we can make sure we get the count right. If you are online, either raise your hand visually or electronically. Okay. Those opposed? The motion fails. Does anyone wish to have their vote recorded? Representative Baker? Representative Potter? Representative Woodard? Representative Clayton? Any further recording of votes? Okay, we are back on the bill. Committee, I think I have one last amendment that I know of. It is a technical amendment. Adam, this is the repeal of 792925B. Committee, I will briefly explain this amendment. It's kind of a technical amendment. The tax lid is contained in KSA 792925C. That tax lid applied to cities and counties only. 2925B was the quasi-tax lid for all other tax entities. All this amendment does is repeal that section so we don't have tax districts that have to comply with two different sections of the law. Does everyone have a copy of the amendment? Okay. Again, this just repeals section 2925B. This is the tax lid that all other entities were under. It wasn't a tax lid. It allowed for some increases according to CPI. Don't ever be afraid to pull out those burgundy books and read them sometime. That's how I found this. Instead of looking online and reading the statute, I was actually reading my statute book and realized that, hey, we've got a section here that would actually cause some double compliance for these smaller entities. So while the cities and counties had their tax lid, everyone else had this one here. Like that. There is one other technical provision of this amendment, and it creates a window on the requirement for the hearing. If If you remember during testimony, we heard some testimony during the hearing that some entities might try to have their hearing too quick, and it would cause multiple statements to have to be mailed, the notification statements. So what this does is it creates a window from August 10th to September 10th. On page 2, it's line 42 of the bill. And that will hopefully prevent a county clerk from having to mail out a notification for a hearing that is very early, when perhaps other tax districts don't have their information together. This will allow for one single consolidated tax notification statement. And with that, I would stand for questions and call for a second. Representative Highland for the second. Committee, any discussion? Seeing none, I will close on the amendment and proceed for the vote. Those in favor, please signify by saying aye.
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 Any opposed? Motion carries. The amendment is adopted. We are back on the bill. Is there further discussion? Seeing none, Representative Mason, would you care to close on the motion for the bill?
Thank you, Mr. Chairman. I will renew my motion to recommend Senate Bill 13 favorably for passage as amended.
Committee, you've heard the motion. All those in favor, please signify by saying aye.
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 Any opposed? The ayes appear to have it. The ayes do have it. The motion passes. Senate Bill 13 has been approved for recommendation. Committee, that concludes our business. I intend not to make this a habit. We're at 5:30.